welcome to Ladies in the Law. This week we are talking about just different stages in the discovery process and deposing and all of the fun things that come with being an attorney. I'm Mikaela, and here is
Allison Melendez.
Let's get into depositions. And
My favorite.
Yeah. You were honestly like the best soundboard to talk to about depositions in the world. Like I'm like, anytime I am stressed or I need one to look at, I'm like, Allison will have the answers.
I love it. I've done a ton of depositions. So it's my favorite. I honestly love depositions.
See, that's incredible. So honestly, like how did you get to that point?
Yeah. So it started off, I think I mentioned it in one of the other episodes. I was working on defense and they kind of just throw you into depositions. So it was trial and error, which if you can avoid that, I would avoid it like the plague. But I did get a lot of skills from that. So I would do multiple depositions. And then now moving over to the plaintiff side, I think I have a little bit more variety. So now, doing depositions of spouses or other general damages witnesses such as children, coworkers, family members. Those are a lot more fun for me. But it's kind of like an interview, so that's why I love doing them.
Yeah. I want to get into that a little bit deeper, but when it comes to doing depositions and like the prep work, so let's kind of talk about the way that you get ready for a deposition, kind of internally and also with the person that's being deposed.
That's a big one. That's probably one of the most important depositions. So do not prep the day before, please. Oh my gosh.
No, because you might need to.
Yeah. Oh my goodness. So I generally will do a call, an introductory call. This is what a deposition is. And it's just like what it is. Then I'll do another call and I'm like, okay, we're going to do a Zoom meeting and we'll prep for your deposition. So I'm going to pretend I'll role play. I'll be the defense attorney and I'm going to ask you similar questions of what they will be asking you. And it's more so to just make sure that your client's understanding the question and listening, because it's so easy to just be like, yes, 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 and get into this habit of just saying yes and not really listening to the question. So
Totally.
For a client's deposition, by that point, you've already responded to discovery. So I usually will either send them the responses again so it's fresh in their inbox, or if they want to meet in person, we'll print them out and I'll go through and I'm like, okay, this is what we're alleging. Remember, on your case, we're not claiming loss of earnings, or maybe we are, and just kind of explain that, because sometimes that question does come up in deposition and they're like, wait, what is that?
Right.
And you're like, I can't coach you on the deposition, but you want to make sure they understand the terminology. So, and that's another question that comes up often in deposition is defense counsel will pull up your form interrogatories, the responses to discovery, and they'll say, have you ever seen this before? And the worst thing you want is for your client to be like, no idea what that is. And they're like, oh gosh. So I always have the discovery responses, make sure we go through those. If there's been any other depositions in the case by that point, I'll refresh my recollection and I'll just read through those. And I usually have like a little summary that I do for myself. And then I have a checklist of things I need to go over. So refresh their recollection on the medical providers that they've seen, refresh their recollection on how much they owe in medical bills, and just make sure they don't have to know the precise language for their injuries or for the treatment they've received, but layperson terms, like what did your doctors tell you? What conversations did you have? And oftentimes clients, because of nerves, they'll just say, I don't remember. Or they just on the record, they'll be like, I don't know. And it's like, you do know, just take a moment. And I always tell them this, it's okay to have awkward pauses.
Totally.
Like take a minute, think. And even if it feels awkward, it doesn't read awkward in a transcript. So I'm sure you do similar things.
Totally. I think one of the best things that like I keep in my head is like, I don't ever want my client to be surprised when it comes to their deposition. I want them to like, I even go over the admonitions with them just so that they're not like sitting there hearing all of these things being thrown at them. Like these are rules that I didn't know. So like admonitions will be like, you are here to tell the truth. You're here to talk about this incident. I am entitled to your best estimate, kind of things where it's like laying the ground rules for how the deposition will play out. I kind of just want them to like feel confident going in, knowing like, okay, these are the things that I'm going to be talking about today. So kind of just, I also like doing the depo preps over Zoom.
Yeah.
Because it gives us an opportunity to see like, okay, is this setup good? Can I hear you? Do you know how to mute and unmute yourself on Zoom?
Huge.
I literally always joke. I'm like, I didn't know how much being an attorney would be like walking people through how to use programs like Zoom or Adobe Sign,
Yeah. Yeah. Oh yeah.
But no, I do pretty much the same way as you. I just don't want them to be surprised by anything. I like to kind of do the role play too, where it's like, okay, I'm going to ask you these questions. You can kind of preempt what the other side is going to be asking or going to be pointing at. Always say like, we have nothing to hide. Yeah. You know, like there's nothing to hide. Like this is a safe space, but also don't do the work of the other side for them. Yeah. So answer what's being asked, but you don't need to give them more information. It's their job to try and get that information. It's their job to ask the right questions and get that. So don't do their job for them.
And don't do the lawyer's job.
Yes.
I always tell them like, you are here to tell the facts, but you're not here to advocate for yourself. Like let us do the arguing, let us do the advocating, because I think the worst thing you can have is your client getting argumentative with the attorney or just coming off really bad, because at the end of the day, that's going to be reported to the carrier and then it's not going to be good.
Yeah. And I think too, like something that I know that you and I both like work on too is like this is the client's opportunity to put a face to the pain that they have experienced. You know, up until that point, everything has been done on paper.
Yeah.
You know, so it's like, we'll have the discovery and they'll have the medical records and they'll have kind of like a paper trail of what this person has been through, but it's the client's first time where they get to kind of like show up and speak to the pain and speak to the experience that they've been through. And so it's like, you want them to do like justice for themselves as well by presenting in the way that like really shows the experience that they've gone through and the person that they are today from that experience.
Absolutely. I think one of the things I tell clients is the only way you can hurt your case is if you're untruthful. And so be truthful, tell the facts, and also like take a moment and listen to the questions. And if there is something, you know, so at the end, kind of jumping ahead, but at the end, usually we get to ask questions too.
Right.
Everyone's different. Some people say, no, don't ask any questions, save those for trial. But I like to ask a few questions at the end, going more towards the pain and suffering, like you were saying. And so I'll just elaborate. So maybe the defense attorney already asked about activities of daily living that they can't do, or hobbies or things like that. But I go a little bit more in depth, and I want the client to give them a little taste of what you would say if this case does go to trial.
Yeah.
And sometimes just naturally the client will get a little bit emotional because they're nervous when they're talking to the defense attorney. But once we start asking questions, we're a little bit of a safer place for them. And so I think they just naturally will elaborate a little bit more. And then that's the perfect opportunity for, if the defense has follow up, like go for it. I welcome it, if anything. So
yeah. No, I totally agree. And so after a client's deposition, is that when you start to kind of look at like the damage witnesses that you would want to start deposing as well? And kind of what's your tactic with, do you start noticing them on your own, or do you wait for them to be noticed by the other side?
Generally, I notice them right away. So especially if this is perhaps a client that is more to themselves or just is not really giving me what I need. Like maybe their spouse just has a better recollection, or maybe their older son or a coworker of a friend. We as plaintiff's attorneys have so much access to our client and to the community around them. And so it's your job to find these individuals. And most of the time I identify them early on in discovery. So they've already been identified in discovery. And then after the client's deposition, I'm like, okay, you know what? I think we're going to notice your daughter's deposition. And so then we'll send a notice, and I'll just go ahead and take the lead. And obviously defense has time to ask questions as well. But I think by taking the lead, I can pull some of those stories out, make them feel safe and open up a little bit more. And then just show defense, like, we have all these people lined up and they're only going to bolster the pain and suffering our client's been through. Right. So
no, I think that's huge. And I think kind of just like a theme is always being like in charge of your case.
Yeah.
Always touching it, always showing that like, we're here, we have nothing to hide. We're going to show you not just tell you all of these things. Like, I want to depose these damaged witnesses so that they can show you the impact that this experience has had on our client. What is the process like for you in determining like who will be a good damage witness for your client?
Yeah, I usually start off with the spouse, and if they're most of the time defense is going to notice their deposition anyway. So I'll speak with them and I'll see if there's any information that the spouse has that the client hasn't told me. So for example, you see this often in TBI cases, so traumatic brain injury cases. I had a client who in her deposition didn't really like talk about any of the TBI aspect. And honestly, I think it's just because her memory's not there.
Totally.
She's got a lot of issues. And so I started reaching out to the spouse, her older children, and they were like, oh my goodness, like these are the things that we've seen. These are, her memory has really just gone out of hand. We're constantly double checking to make sure she's taking her medication. These are the things we've seen. And then also just kind of listening to changes. So like, this is a mom that I had that was so fun before. We would go dancing together. We would go, on vacations together. And now I just don't see her anymore. And so I make notes of that. And I'm like, okay, mental note like this. I think this would be a really good witness to depose. And especially for clients that don't have the best testimony or that maybe like their testimony was missing an aspect of the case. I think you have to find these individuals. And you don't necessarily have to depose them right away, but I think it's strategic too. Like if you see that the case is stalling and there's been no movement from defense, like go notice one of the general damages witnesses and let them see what testimony could potentially be used later at trial. Definitely. And we always videotape them just in case, God forbid your witness isn't available. You can just play that video at trial. But I think it's not always just the immediate family. Like I think you saw that recently in your trial. There were general damages witnesses from all aspects of life. If you want to talk about some of those, would be great.
Totally. I think a big part in like choosing your damages witnesses is kind of thinking like, where are gaps that need to be filled? And that might be like what you're saying when it comes to that client. Like, I think sometimes it's incredibly difficult to sit and be like, how am I a changed person from this? And talk about all of that when all you're trying to do is heal and exist, and like face your new reality. But if you're constantly sitting in this mindset of like, well, like, how is my life worse now? Like, that's hard to heal through. And so I think what you're talking about is kind of filling that gap of like, okay, like maybe it's too hard for this client to truly like go into that. Yeah. But I know someone, because of all of the work you've done leading up to that point, that would be able to talk about that pain and like their experience and their witnessing of that. And so the case that you're talking about that I just did, my very first trial ever.
It's amazing. So fun.
It was our client had lost his dad, and his dad was a coach, a mentor, a like my house is your house kind of human being. And so our client was an only child. And so he didn't have siblings. His parents were separated, and the co-parenting was incredible. So we definitely did have our client's mom as one of the general damage witnesses. Yeah. But he had so many friends that looked up to his dad that they were incredibly impactful. And they got to witness the relationship between our client and his dad. And they also had their own relationship with our client's dad because of the way that he showed up for his community. And so I think like it's exactly what you're saying. It doesn't have to be blood because, I mean, at the end of the day, like chosen family is huge, you show up when like you choose to show up. And in that case, like the deceased, he chose to show up in so many people's lives. So it was honestly hard picking which ones, because everyone also wanted to step up and use their voice to like keep his memory alive. So
how did you guys get around? I know sometimes defense will argue, you have all these general damages witnesses and they'll say it's cumulative. They're all testifying about the same thing. Like it's going to be prejudice our client. How did you guys get around that?
Yeah, the way that we got around that was that each person kind of had something that they were talking about that was different. So one would talk about the mentoring relationship. One would talk about he had not a close relationship with his father. So then he talked about the way that the deceased showed up for him in those ways. One was another coach that got to talk about his relationship with his own son and how he thought they were close until he witnessed our client and his dad's relationship. So it kind of has like a unifying theme, but each person's like topic was different than the next. So it all kind of went to the same thing of like talking about their relationship, but it was different aspects of their relationship, which was the way we got around that.
I love that. I think that just kind of speaks to when you're a really good advocate and you've seen the community around your client. It's your client's not going to tell you, oh yes, you should call this person, and this person. They'll have a general idea, but you have to kind of like pull these stories out from them. Like, what do you do in your free time? Who do you hang out with? Who do you see? Who's like an active member of your life? And then building that through building a rapport with your client, which we talked about in one of the other episodes, but that's how it just comes full circle. Definitely. It really does.
It really does. Yeah. And when it comes to you doing those depositions, how does the prep work with people that aren't your client?
It's tricky. So first, I always ask if they're even willing to sit for a deposition, take time out of their day. And I run them through the process and then ask them questions. I let them know, like, look, you can only testify about things you've observed. So don't speculate, only talk about the things that you know. And then for myself, in terms of prep, I go through our client's deposition. I go through any other existing depositions in the file. And I just look for anything that would potentially, one, contradict any testimony our client has made. And then also like what would help bolster his testimony. So oftentimes it's going to be the spouse. That's like the natural first one. But if it's the spouse, it's a little bit easier because if they've been with the client the whole time, sometimes, they separate. So it's different, but they'll have a really good knowledge of all the treatment. Like I went with him to all the doctor's appointments. And so you can pull that information. And so like with any deposition, I make my outline. I focus on key issues and it usually comes out with background information. I want the background of this person. What's their job title? Any felony convictions? Is this a person that would testify well? Right. Then I go through pre-incident. So before this incident happened, what was your relationship like? Provide examples. So anytime that you ask in a deposition, can you provide an example? It really helps them think like, okay, let me think of a key story or something. So I'm always like, okay, you testified X, and can you provide an example of that? And based on your observations, can you provide an example of how this is different? So I do pre-incident. Then I go into, okay, this incident happens. How much do you actually know? When did you first learn about it? And if it was in the moments shortly thereafter, that kind of goes to how close the individual was with this person. And then the last portion of my outline is post-incident impacts. So provide examples of things that you've observed that are different now. And then typically after they've listed a bunch of different examples, I'll say, okay, so at the very end of this deposition, I think you provided all of these examples. And can I just ask you, what is the one that stands out the most to you? Or if you had to just point to one specifically, what is that example or difference that really just is different for you now? And I just give them that opportunity because it forces them to think and just kind of pause. And then I conclude there, let defense ask questions. And for the most part, I think you can just get so much little gold nuggets and sound bites, and it really does help paint the case. I've had like general damages witnesses testify, and then shortly thereafter we get a request for mediation, or we'll get a 998 sometimes. So it really, you can't underestimate the power of a good general damage witness deposition.
No, I couldn't agree more. And I think it makes it so well-rounded.
Yeah.
Where it's like this person is so loved and this person is so seen, and they have people that are willing to stand up for them and use their voice to continuously advocate for them. And knowing that someone has that community is powerful.
Oh yeah. I think it just speaks to, these are individuals. Like I think oftentimes I don't want to assume, but oftentimes, defense attorneys are busy. And so if you can humanize your client and show the community around them, like this person's taking time out of their day, their busy day, to sit for a deposition, be questioned by both sides, like that says a lot.
Yeah.
And I think it's super powerful.
I could not agree more.
I love it. I love those depositions.
Well, thank you so much for sharing the way that you go about it with all of us. And thank you guys for tuning in to Ladies in Law. We'll be back in 2 weeks.
Yes. See you soon.